I'm Ben Andriazzi.
And I'm Jennifer Storm.
We've spent our careers fighting for victims
and standing up for survivors of sexual abuse.
On Justice Interrupted, we have honest, often difficult conversations
with survivors, advocates, and experts fighting for change. Because justice should never be delayed and never interrupted. Welcome to Justice Interrupted, a podcast where we confront the systems, institutions, and individuals that stand between survivors and justice. I'm Jennifer Storm. I'm joined by attorney Ben Andriazzi, and together we amplify survivors' voices, examine the issues shaping victims' rights, and speak for advocates, experts, and change makers working to create meaningful change. Just because justice may be interrupted, it should never be abandoned. So Ben, we're excited to have our guest today to talk about what's happening in Rhode Island.
Yeah, so I think today is going to be insightful to give us a picture of what we hope will sort of sweep throughout the country, which is this idea that legislatures are eliminating statute of limitations and allowing survivors of sexual abuse to come forward. So today we are excited to welcome Eric DiMario. Eric is an attorney with Kiernan, Plunkett, and Redahan. They have offices throughout Rhode Island. Eric is a 2004 graduate from Suffolk Law School in Boston. He has, for multiple years, been identified as a rising star in super lawyers. So, Eric, welcome to the podcast.
Thank you, Ben. It's great to be here.
So, Eric, whenever I have attorneys and I think a lot of our guests, I'm sort of interested to learn how they got to where they are. So, can you tell us a little bit about sort of how you got to be in the position you're in and maybe when and how you knew you wanted to be an attorney?
Sure. That's a big question. I actually had kind of decided I wanted to be an attorney at a very young age, much to my parents' delight. But then by the time I had gone to college, I decided that was definitely not for me. I didn't want to be a lawyer. It seemed like too much of a headache, too much schooling. And I was going to be a sports writer. Pretty much settled on that. And then when I was in college, some of my friends had gotten into some trouble. In the retrospect, nothing too serious. But the way that they seemed to be railroaded by the university's judicial system really kind of opened my eyes to, again, what was on a very low level, just something that seemed inherently unfair to me. These fellas' academic futures were at stake, and they weren't allowed to consult with an attorney. They weren't allowed to do a whole manner of things. Now, in the end, again, nothing too serious, and not a lot came of it. But that experience really frustrated me to see that something like that could play out. And I kind of went back, like, maybe I do want to do that. And then I did end up going to law school, and here I am 20 years later.
So I think you've been with KPR for about 16 years at this point. Tell us a little bit about the firm.
So Kiernan, Plunkett, and Redahan, KPR, has been operating in Providence since 1984, when I was just in grade school. And they were, for a long time, kind of like an old line defense firm doing almost exclusively insurance defense in Rhode Island. That started to change for them probably in the 1990s, when a lot of insurance companies began taking their defense work in-house, and they very slowly started broadening the types of work that they would take on. They started doing more and more plaintiffs' work. And by the time I started here, as you said, about 16 years ago, we were probably about 50-50. We were still doing about 50% defense work, but solidly 50% plaintiffs' work. And that imbalance has continued to grow. Well, balance then, now imbalance has continued to grow, in that we have, I don't know how much defense work we have left at this point. We may have a handful of files. Somebody has a conflict and our name still shows up on a list, but right now we're almost exclusively plaintiff or private client work.
Tell me a little bit about what sort of sparked your interest in this specific niche or genre, so to speak, of the law, which is representing victims of crime in civil cases.
I think in the beginning it was kind of the same idea of ensuring that people who are harmed could have some measure of justice or access to justice. And one of the very first cases that, no, not one of the very first case I tried, my client had been very badly beaten in a social club. And the person who attacked him got almost no jail time. And that to me just seemed very unfair. And that was, as I said, the first case we took to trial, also against the social club that allowed it to happen, because the evidence had showed that they did not want to get the police involved. They tried to cover everything up. And so even though we felt like maybe the criminal justice system did not do all of the justice that we would have liked, we were able to get a remedy through the civil justice system. And so I guess that's kind of where my interest in doing that type of work came from, at least earlier on. And it's transitioned a little bit and transformed as I have learned more and more about some of the issues I know we're going to talk about today, just through stories in the news and movies and podcasts and miniseries, things that a lot of people have probably seen either on Netflix or where have you. The one I'm thinking of in particular is the Spotlight series about the Globe reporters in Boston. Go on. Sorry.
Yeah, no, I mean, so tell us a little bit, in particular as it pertains to Rhode Island, and civil litigation and the statute of limitations. Can you tell us about the progression of where we have gone in say the past 10 years or so?
Sure. So the first real robust effort to try to change Rhode Island's law on the statute of limitations happened back in 2019. And this was shortly after I had started to learn about other efforts around the country to change these laws, because so often you'd hear these terrible stories about children who were victimized and abused, and I think for a long time there was a collective shrug. Well, there's nothing we can do. So long ago, all of these claims are time barred. Nothing can be done to fix that. And little by little around the country, I think people started asking the question, well, wait, maybe there is something we can do. This was especially in light of the science behind the way a lot of people who were victimized as children come to terms with what happened to them for many, many years. And the science shows us this. They repress those memories. They're not able to deal with them, oftentimes until they're in their 40s. And by that time, even lengthy statutes of limitation have passed. And I know that was a defense in other jurisdictions and in Rhode Island in 2019, when this effort first started. They said, well, we can make the statute of limitations 7 years or 10 years or 15 years. And what we were learning was even a lengthy statute of limitations like that is just not enough for this type of claim. And then I said in 2019, that was the first meaningful effort to change this law. And I remember, because I testified before the General Assembly in support of the bill then back in 2019, and all of the advocates for these changes in the law and a lot of victims that I knew about from media, from Spotlight, people from Massachusetts, came to Rhode Island to testify. And I remember thinking to myself, well, this is great. We have all of this support. There's no way that this bill is going to pass and become law. Who could possibly be on the other side of this? And, well, we learned in short order there were many well-funded interests who were very much opposed to changing this law, and it did not pass in 2019. And since then, there have been a couple of iterations. It's kind of a start and stop. There'd be some momentum, and then it would fade. And there was one law passed that it didn't accomplish what this one does. It exempted the entities that enabled these perpetrators. They were able to escape justice based on a slight variation in the wording of the law. But now, finally, here we are in 2026, and a true reform bill has passed, one that fully opens the doors of the civil courthouse to victims.
I think one of the problems with just merely changing or expanding upon the statute of limitations and saying, okay, well, right now it's age 30 and we're willing to move it to age 55. Is there still so many people who don't fall within that window, and there are perpetrators who cannot be identified. The criminal, especially if you have a short criminal statute of limitations, so they can't be charged through the criminal statute of limitations because that can never be changed. There are constitutional problems with that. But if you're merely adding, 7 or 10 or 15 years, there's still going to be dozens and dozens, if not hundreds, if not thousands of perpetrators who can go under the radar. And I think, when most people think of a window, they think about, a window in a civil case, they think about the financial damages, right? And that's great because survivors certainly need restitution,
Sure.
but they forget about this idea of identification. Because if we can't identify the hidden perpetrators through the criminal courts, because can't change those statute of limitations, you're never going to find them unless they get named in a lawsuit.
Yeah. That's like the biggest mechanism used to fight against these laws, right? They make it that the victims are greedy, they're looking for money. And as Ben said, it's often about that discovery that happens and that disclosure, which is equally as important, if not more important, for a lot of these survivors.
So the idea of trying to identify perpetrators and then also through that process identify victims so that you can, as you say, one aspect of this is compensation, but the other aspect of it is just getting these folks the help that they need, because I think a lot of them have been dealing with issues, their own personal demons, and they don't know where they come from necessarily because they've buried this so deep. And one of the things that I found very frustrating, I met a physician, Dr. Hub Brennan, at that hearing. And I know he has been pushing for this type of reform for a long time. He has his own experiences with this fight. And he relayed both in testimony and just in conversation that when he started to realize that there were probably so many people out there who had not come to terms with what had happened to them, and that really needed help, whether it was, counseling or some other type of treatment. And he had approached one of the local dioceses, and forgive me, I don't recall which one, just about trying to come up with a plan to help identify these folks, reach out to them and get them in touch with the resources they need to help, so they can help themselves. And as you can imagine, he was met with a collective shrug, and that there was no interest in doing anything that might identify someone who was a victim of this conduct. And that's why this change in the law is, I think, so necessary, because you're going to identify people that engaged in this, type of just evil conduct, but you'll also identify folks that need help, whether, again, compensation is one aspect of it, but getting these people to come to terms with what happened and getting them connected to other survivors groups, to the therapy and medical resources they might need. I think that's at least equally, if not more important.
Yeah. And the policy change too. I don't think people recognize that how often in civil cases, there's the ability for survivors to impact the policy of that institution that failed them. And that is a huge goal, because it then kind of gives that promise, if you will, that there are now safeguards in place that hopefully this will not happen again, right? And that's a big deal for advocates and survivors as well.
Absolutely.
Eric, I've got a question for you. What is the most exhilarating experience that you have had as an attorney? I'm going to give you 3 different options, 3 different potential answers. Number 1 would be trying a case in front of a jury. Number 2 would be arguing in front of a hot bench, meaning a judge who may not agree with your position on the law. And number 3 would be testifying in front of the legislature. Because I believe you've done all 3, correct?
I have. Yep. That's a good question. And I guess I can immediately rule out option 2, because I find that, unfortunately, that seems to happen a lot. I find myself in front of a judge, and I'm trying to get the court to do something, and maybe we're just not seeing eye to eye on it, or maybe my opponent is just a better attorney than me. But so that happens too often to be all that exhilarating. The other 2, that's a tough one. That's a real tough one. I mean, getting that vote from a jury after a trial. That is some kind of wonderful feeling. Your client is standing right next to you. You see their reaction. It's hard to. That's hard. I mean, hard to top that. But I will say, when I was testifying on behalf of this bill, and that very first time, I don't know how this worked out, but at the table with me was someone who had been sent from the tort reform lobby to testify in opposition to the bill. And there was a little bit more of a back and forth than I would have anticipated, because, he had made some points, and I knew the chairman presiding over the hearing, and I was allowed to kind of try to rebut some of his arguments. And so that felt good. It really did, be able to say, well, wait a minute, like these arguments, don't be persuaded by them because they're not valid. So even though that first one is very hard to top, I'd say they're pretty close, those two experiences.
What were some of the arguments that the hired gun lobbyists or whomever it might have been testifying against the window legislation was making?
So there were a couple that stood out in my mind. One of them is the constitutionality issue, which I certainly understand. I do think that laws of this type are constitutional. I'll speak just to here in Rhode Island. I think that if there is an eventual challenge on constitutionality grounds, I think that our Supreme Court will uphold the will of the legislature and the voters, and I think they'll find that this law is constitutional. And my suggestion at the time in response to that was we could consider this a remedial statute. For example, our workers' compensation law applies retroactively and is a remedial statute, and no one seems to kick up a fuss about that being constitutional. So why couldn't this be a remedial statute to right a far too long-standing wrong? It never came to that, because obviously they passed the bill of their own accord, but that was one option. And then the other issue, and I hear this a lot, and I'm sure you folks hear it a lot, is that, well, so much time has passed, and people have died, and memories have faded, and records are lost. And I said, in response to that, I always said, well, who does that benefit?
Yeah.
I'm sure that these victims would have very much liked to have had their day in court when everyone was still alive, when all of the memories were fresh and all of the relevant documentation was at everyone's fingertips. It was the people enabling the perpetrators that covered it up, that delayed justice for as long as they possibly could. So if they feel that they are somehow prejudiced by the passage of time, they have nowhere to look other than in the mirror. I've always felt that way.
I love how they also seemingly forget the fact that the plaintiff carries the burden of proof in a case. So in a civil case, an attorney, representing the victim or the plaintiff, they still have an obligation to prove their case by a preponderance of the evidence. They need the so-called scales of justice to tip ever so slightly in their favor. So guess what? The evidence that you're going to weigh on your side of the scale is going to be even more difficult to obtain and acquire. So that's a problem that the plaintiffs have, that,
Absolutely.
the memories fade and the evidence doesn't exist. These SOL laws, these window laws, don't decrease the burden of proof for the plaintiffs or make the plaintiff's case any easier. So that argument doesn't resonate with me.
And especially given that, and I'll just talk about the church specifically, the records are there. The meticulous record keeping that has been uncovered through some of these grand juries and some of these cases is quite fascinating. Some of these entities kept really, really good records. And, for the civil attorney to finally be able to pull those up and out and expose them has, I think, been really eye-opening for a lot of folks too.
That's a very good point.
Yeah, we see in a lot of the dioceses, you have different files. You have a file which will outline where the priest was located, where they were moved, things of that nature. And then you have, what we call like a secret file, which involves any sorts of allegations of misconduct, and only certain individuals, high-ranking officials, had authority to get to those documents. So I'm hopeful. We've both Eric and myself, both having cases, related to the diocese throughout Rhode Island. We'll have an opportunity to dig into some of these files to see what exists, and that's the other piece of sort of this puzzle is, for survivors, a lot of justice and healing is getting answers to questions. Things like who knew what when, and if these records that the diocese was holding have, complaints from other people and have statements from priests who were aware, or from bishops that were aware of this. And you can present your client with that information. It can be incredibly empowering in sort of this journey to reclaim, their childhood. So we'll see. Eric, I have a question related to the window in Rhode Island and sort of the particular details of it. We've seen in other states, like in Maryland recently, issues like caps on damages. We've seen issues related to like sovereign immunity, meaning which defendants, whether you can sue governmental defendants. Can you speak just sort of broadly about the types of institutions that this window applies to, and maybe any strings that are attached to it?
Sure. So in Rhode Island, the window is quite broad. It's a big window, meaning that you can make a claim against virtually any type of entity, whether it's private institution or municipalities. Now, flowing from that, there are certainly situations where the specific type of claim that I suspect will frequently be brought under this window period, you may very well run into certain caps on damages against municipalities. There may be certain ways to argue around those. And I think that as we go through this process, and I've been speaking with a lot of my colleagues that are also practicing in this area, we've already tried to start putting our heads together to come up with ways that we can deal with that and overcome that. Because in Rhode Island, traditionally, there are not, we are fortunately for victims in Rhode Island or injured persons in Rhode Island, we don't deal with damages caps a lot. But specifically as to some of those municipal claims, that could be a problem.
Eric, is there anything else you want to add for our audience?
I mean, I think we've covered a lot of it. I guess I would just say that I'm very hopeful that laws like this, especially here in Rhode Island, which I'll speak to because that's where I'm from. I hope that this is the last time that we have to deal with this problem on this scale. And that I think people in maybe only the last 10 years have really started opening their eyes to the idea that this type of conduct should never be tolerated. It should never be covered up. I mean, the idea of like, oh, what do we do in response to this? In response to a report of this type of conduct, the call should be to law enforcement immediately. No ifs, ands, or buts. And it's unfortunate that I think that it's going to take the ramifications of the civil justice system to force people to do the right thing. But I'm hopeful that it will, and that the next generation and generations in the future will not have to deal with the cover-ups and the conspiracies that children have had to be victimized by for these last few decades or more. So I'm really hopeful that this is going to be a kind of like the dawn of a new legal day for the way corporations, entities respond to reports of this type of conduct.
Yeah, Rhode Island's a small state, but I think this law could have big implications. So my firm is actually proud to have partnered with Eric to serve as local counsel on the Rhode Island claims that we're bringing against organizations on behalf of survivors of sexual abuse. If persons want to get in contact with you, what is the best way for them to do so?
So you can go to our website, which is just very easy. It's kprlaw.com. You can give us a call, 401-831-2900. You can certainly email me if you want to directly. And that's just my first initial E, my last name, DiMario, DIMARIO, at kprlaw.com.
So Eric, thanks so much for everything you've done. Thank you for your efforts to get this legislation, to the point where it is. And we'll look forward to hearing from you and working with you.
I look forward to it as well. Thank you very much, Ben.
Thank you.
Thanks.
And thank you for listening to Justice Interrupted. If today's conversation resonated with you, please follow our podcast, share this episode, and help us continue amplifying survivors' voices. Until next time, remember, justice may be delayed, denied, or interrupted, but together we will never stop fighting for it. Thanks for joining us on Justice Interrupted.
If this episode moved you, informed you, or gave you hope, please share it.
And don't forget to follow, rate, and review the show wherever you're listening.
For more resources, links, and ways to take action, check out the show notes.
Until next time, keep speaking up, keep fighting for justice.